The case began with the court identifying the parties, including Steve Lane and Mrs. Barkdale, who was the plaintiff. Mrs. Barkdale explained that she and her husband had heard a radio advertisement in Nashville, Tennessee, promoting a pill that supposedly enhanced breast size. At 42 years old, Barkdale said she still wore a bikini and wanted some additional help with her breast size, so she became interested in the product. After hearing the advertisement, she called the company to place an order. However, during her first call, she did not ask about the price, the number of pills included, or the recommended dosage. Later that evening, her husband asked her about the order. Barkdale admitted that she had been so excited about the product that she had forgotten to ask those questions. Her husband told her to call the company again and find out how much the product cost, how many pills she was supposed to take, and whether she would need additional pills later to maintain the results. The following day, Barkdale called the company again. She was told that a 6-month supply would cost $1,530. Barkdale said that she could not afford that amount and immediately asked the company to cancel the order. She had already provided her credit card information. According to Barkdale, the company representative assured her that the order would be cancelled. The representative explained that most of the company's computers were not working and that only one computer was operational. She told Barkdale that she was writing down the cancellation request and would enter it into the working computer after they ended the call. Barkdale then spoke with her husband. He suggested that she call the company again and ask whether a smaller order was available. She contacted the company again and spoke with the same representative, Dorothy. Dorothy told her that a 2-month supply was available for $515. Barkdale discussed the price with her husband, and after he agreed, she called Dorothy again to place the smaller order. Before doing so, however, Barkdale specifically asked whether the original order had been cancelled. She said Dorothy again assured her that it had been cancelled. Barkdale also called the company 2 days later because she had been told that the shipment would arrive within that period. She said that both she and her husband called the company several times, and each time they were told that the original order had been cancelled. Despite those assurances, several days later Barkdale received both shipments. The deliveries included the original 6-month supply and the later 2-month supply, giving her a total of 8 months' worth of the product. Barkdale immediately contacted the company and requested a refund. However, she was told that the company had a no-refund policy and that the policy was printed somewhere on the packaging. Barkdale disputed that claim and presented the packaging to the court. She explained that the product had arrived inside a parcel, with the actual packaging placed inside a plastic bag. Judge Judy examined the packaging and understood Barkdale's point that the supposed no-refund notice was not immediately obvious. The court then asked whether Barkdale had used any of the product. Barkdale admitted that she had used the entire 2-month supply. She said the instructions allowed customers to take 10 pills, with the option of increasing the amount to 15. She claimed that she followed the instructions faithfully because she was extremely excited about the possibility of seeing results. However, after completing the 2-month supply, Barkdale said she saw no improvement whatsoever. She emphasized that she was 42 years old, had 8 children, and still wanted to be able to wear a bikini, but the product had produced no results. Judge Judy then addressed the amount Barkdale was seeking. Barkdale initially appeared to be asking for the $1,530 that she had been charged for the 6-month supply. However, Barkdale attempted to amend her claim and asked for a much larger amount. She ultimately stated that she wanted approximately $2,400, and then mentioned a total of $5,000. She explained that the amount included the cost of both shipments, which totaled approximately $2,045, with the remaining amount being requested as punitive damages.